for joining us. We're going to spend some time today talking about the E-2 visa investor requirements and renewal considerations. A few things before we get started. Some of you may know that the firm was founded on an E-2 visa several years ago. Our founder, Ian Scott, is here personally on an E-2 visa, so he's very familiar with this process and what clients are going through. Our firm is also a full-service immigration firm focusing primarily on E-2 visas. We've processed hundreds of them. We typically process E-2 visas that are higher risk, meaning lower investment amounts. We've processed at consulates around the world, but our primary two consulates are Toronto and London. We'll continue this webinar series, doing at least 2 webinars a month on different topics. We have a webinar coming up later this month, and we'll continue doing 2 a month. At the end of this webinar, we'll send out a few things, a PowerPoint that you'll see today, our E-2 visa guide, which is a comprehensive guide to E-2s, and a link where you can sign up for additional webinars. For our panel today, we're really lucky to have Dustin Saldariaga, an associate at the firm who has vast experience with E-2 visas. I will also be presenting. My name is Kelly Weiner, and I'm the managing attorney at Scott Legal. If you have any questions, please add them in the chat box, and we will answer them, either at the end of the webinar, or we'll continue to do so throughout the presentation if it's on the topic that we're presenting on. So without further delay, I will turn it over to Dustin to get us started.
Great, thank you, Kelly, and hello, everyone. Thank you for joining us today. We'll start the presentation by talking about the E-2 visa's basic rules and regulations, what you need to keep in mind if you're considering applying for an E-2 visa. And of course, these requirements would still need to be in place if you're renewing your visa. First of all, the E-2 visa is a visa based on a treaty that the U.S. has with the country where the applicant is a citizen. So it is a non-immigrant visa, meaning that it does not directly lead to a green card. And it allows individuals to come to the U.S. to develop and direct an enterprise in which they've invested and they own at least 50%. There are a few typical ways that individuals actually develop the business or purchase it. Typically, an applicant would either have a startup that they've developed from scratch, or they've purchased an existing business, or finally, franchises are quite common in the E-2 context, where an individual will start, say, a sandwich franchise in the US. All are quite common pathways for individuals who want to apply for an E-2 visa in the US. As I mentioned before, there must be a treaty between the US and the country of nationality. So you can check that the list occasionally changes, but there are dozens of countries on the list. So the best way to know whether your country is a treaty country is to Google US Department of State E-2 treaty countries, or even just E-2 treaty countries, and you'll see that there are a number of countries, and they span the world: Europe, Africa, Asia, Latin America, the Middle East. So odds are, if you are listening to this presentation, your country, there is a good chance your country is on the list. We already do have a question that touches on this. Many countries are not on the list. What we do see is that individuals, for example, India, China, are not on the list of E-2 treaty countries. What is an option is to apply for citizenship in a third country. Grenada is a quite common example, where you can quite quickly apply for citizenship based on investment in a third country, acquire a passport and citizenship from that country, and then use that citizenship for your E-2 visa. That is a path that is actually not an uncommon way to pursue an E-2 visa. E-2 visas tend to be valid for between 3 months to 5 years. This really does depend on reciprocity in general, where if basically there's an agreement between the treaty country and the US, whatever amount of a period of status one country grants, the other country will grant as well. So for any visa, however, whether it's 3 months or 5 years, when you enter the US, you're given status for generally 2 years. So even if you arrive in the US on the last day of validity for the visa, say you have a 3-month visa and you arrive in the US on the last day that visa is valid, you should still get 2 years of status. And that's assuming that your passport is valid for the entire period of your stay. So let's go into a little bit more detail on these E-2 visa requirements. All of these are essential requirements. One of the most I'll say most critical. It involves a lot of time and effort actually in the application process. And when we work with clients, we spend a good amount of time speaking about the investment requirement. So the applicant must have made an investment in the E-2 business. So again, whether they are starting a franchise, whether they have a startup, or whether they are purchasing an existing business, the applicant needs to have committed funds to the business. The funds must actually be at risk. And what that means is they need to actually have been spent. It's not enough for an applicant to say have put $100,000 into a business bank account that they can then theoretically withdraw and take back. The money has to actually have been spent. It needs to have been spent as well on a variety of items that are necessary for the business to become operational. And we'll touch on that in a moment. You'll see on this next bullet, the source of funds. This is another key piece. The government needs to be satisfied that the funds that were invested in the business were acquired through a legitimate or lawful means. If you're applying at a consulate, this is a requirement that consulates tend not to spend a ton of time on. They want to be satisfied, of course, that you meet the requirement, but they're not going to do an audit, which is closer to what would happen if you applied within the United States through USCIS. So that's in contrast to a consulate. What they're looking for is really that, again, that the funds were acquired through a lawful means. The means can vary. The funds can be acquired from a gift, from a friend, family, really anyone, from a loan, as long as the loan is not secured by assets from the E-2 business. You can also, use funds that you've saved from work, earned income. If you sold a property, a house, for example. All of these are legitimate ways to acquire funds that can be used on the business. The important thing and what we would do in an application is really to document each step of the process. So for example, if the funds are earned income, we would want to include your tax returns for the last few years for the period in which you acquired the funds. We'd want to show that the funds were deposited in your bank account and then transferred to a business bank account. Same with a gift. We would want to include a letter from the person who gave the gift, signed by the person making it, and explaining, the circumstances that this is a gift. There's no intention of clawing the money back. And we would also typically provide the same documentation for the person giving the gift. If it's earned income, for example, we'd want to include their tax returns. Again, an application at a consulate can go fairly light on this documentation in general. With USCIS, we really would want to trace each dollar from its origination to actually being spent on the business. One of the issues that frequently comes up is, the purpose of investing funds is both the amount that needs to be spent, but also showing, as I mentioned before, that money was spent on all of the things that need to make the business operational. So typical expenses include rent. It is important, even though it's not an explicit requirement of the E-2, it is important to show the government that you have a space where the business can operate. So spending money on office space is a very common example of an expenditure. Purchasing any inventory that's needed for the business, purchasing equipment such as computers, phones, setting up a website, buying office supplies. These are all very common expenses. And really the way to think about this is, what are all of the things that I need to purchase so that this business becomes operational and is ready, meaning is ready to begin generating a revenue and hiring people as soon as I receive the visa. And you really want to show through, say, an investment schedule, a spreadsheet that you would include with your application, that you've spent money on each of those items. Finally, on this first section here that you see on the screen is escrow. We mentioned escrow. So very understandably, the applicants very commonly are worried about spending money before they have a visa. What if they spent $100,000 only to find out that their visa is denied? Very understandable concern, and there is an option here to use escrow. So escrow is actually the one exception that the government will accept short of actually spending the money. So I mentioned before, you don't want to just put money in a business bank account. That won't be sufficient, but it would be sufficient to put the funds into an escrow account. Say if you're purchasing a business, put those funds in the escrow, and the sole condition for release of the funds is issuance of the visa. So that is common, that is acceptable to the government. I see a few questions coming up. Does one have to be from a treaty country? I'll assume that question is about the funds. The funds do not have to be from a treaty country. For example, if someone is a national of Colombia and is working, say, in the US on an H-1B and has saved money, they can use money they've earned in the US and spend it on the E-2 business. So US is, money earned in the US, or really any country, as long as the individual has treaty country nationality, that requirement is satisfied. I also see a question here: when purchasing an existing business, do the purchase funds need to be transferred prior to the initial E-2 application or prior to the consulate interview? Great question. The answer is yes, the funds do need to be transferred prior to the application or prior to the interview. Really, prior to the interview is the answer. So right now, especially, we'll talk a bit about this. There are delays at consulates. So some consulates are taking 6 months, even closer to a year after the application submitted to schedule an interview. As long as the funds have been transferred prior to the interview, that really is the key piece. But the caveat to that is, an application goes to a human, right? All these consular officers are human. They're going to look at an application, and if they see an application where no money has been spent, there is a good chance that the application will be denied as not having met the threshold requirement. However, technically, the requirements need to be satisfied before the interview. So you really do want to make your application as strong as possible at the time of submission. If there are things you need to add after submission, generally that's okay. Again, the one exception to that is escrow. So you can put the funds in escrow so that even at the time of your interview, the funds haven't been released yet. Once the visa is issued, the funds are released. Can two people from the same treaty country invest 50% each to buy a business? The answer is yes. We'll talk a bit about ownership. 50% is the threshold requirement for ownership. So if two individuals are each from treaty national countries, they can invest as 50-50 owners. Their investment amount, if they're both applying, should be about evenly split. All right, so let's continue down this list of requirements. Critical requirement: the business cannot be marginal. That means that the business must generate sufficient revenue to support more than the applicant's family. In other words, the business should employ US workers. What we generally recommend is that within 5 years of operations, the business should employ between 3 to 5 US workers. The more, the better. But generally what the government is looking for is 3 to 5 workers within 5 years. The business must be real and operating. So a passive investment is not sufficient. This comes up where, for example, people want to come to the US to manage an investment fund. That is generally not going to work for an E-2 visa. What you want to show is that this is a business where the applicant needs to be on a daily basis engaged with the work, employing workers, really developing and directing the business. Also, this gets to what we were talking about before, where you really do want to get the business to a point where once the visa is issued, The applicant is ready to come to the US and begin generating a revenue and employing workers. An E-2 visa is not intended for someone to come to the US and at that point begin looking for a business to start or a business to purchase. That should already have been done when someone applies for an E-2 visa. In order to do that work, people would instead apply for a B-1 visa or come to the US on ESTA, for example. Both of those options, it's perfectly fine to come to the US to have meetings, to even hire workers and start signing contracts as well and developing the business before you actually apply for the E-2. The applicant must solely develop and direct the E-2 enterprise. So the applicant needs to be qualified to run the business. Usually this is quite easy to satisfy, but you do need to show that, again, the applicant is not coming to the US simply to engage in a passive investment. Really, they are coming here, they're qualified to run the business, and that's going to be what they're committed to. As an E-2 visa holder, you don't have the ability to work for other employers. You really are committed to your enterprise when you're in the US. You must own at least 50% in the E-2 company. I mentioned this before in response to the question. The moment the applicant's ownership drops below 50%, they become ineligible for the E-2 visa. So it is absolutely critical that an E-2 visa holder maintain at least 50% ownership in the business. And again, it is possible to apply with a co-owner, but because you must satisfy the 50% requirement, both co-owners must own 50%. In order for them both to receive an E-2 visa. It's also perfectly fine to have a co-owner who's a US citizen or a green card holder, so long as the E-2 treaty country national owns at least 50% of the business. And finally, on this list, you'll see you must have the intent to return to the home country upon the expiration of the E-2 visa. So again, the E-2 visa is a non-immigrant visa, meaning that you are not allowed to have the intention to enter the US in order to adjust status and pursue a green card. So you basically, this is usually a quite easy requirement to satisfy. We would include in our applications a signed letter that explicitly says that I'm applying for an E-2 visa. My intention is to depart the US at the end of my visa term. All right, so I have a question here. Can I run the existing business with the same manager and staff level and just run without actually working on a daily basis? So it is, you do need to develop and direct the business on a daily basis. So you do not need to be, and actually should not be, the one providing services to customers. However, you do need to be the one that is managing the business, that is running the business on a macro level and really charting out the course of the business. And that does need to be done on a daily basis, really. Now, there's no requirement that you spend a certain amount of time in the US. You can travel freely. So it really is up to you as the business owner exactly what it looks like to develop and direct the business, but that is an explicit requirement. All right, let's move on to the next slide. How much investment is enough? So the government's requirement is that the investment amount must be quote unquote substantial. That's the word the government uses. They don't provide a specific dollar amount. There's nowhere in the regulations or in immigration law that says if you invest X dollars, you qualify for an E-2 visa. But what the regulations do say, they use this word substantial, and that's been interpreted to mean that enough needs to be invested in the business to make it operational. So there's a test that has been developed called the proportionality test. And again, this is really for startups. So a lot of people apply where they're starting a business from scratch. How does the government determine if enough has been spent on a startup to make it operational? Really, this is an art more than a science in many cases. But the question is, for a business like a service-oriented business, such as a consulting firm, there's not a lot of expenses that are required to make that operational. Oftentimes, if you have, an office space, a private office, even at a WeWork, a computer, a website, you can begin generating revenue and you can begin hiring workers. And that's understood by the government, that say a service-oriented business like a consulting firm would require less funding than say a business that's going to start manufacturing electric vehicle batteries, which would require a lot of money. So that kind of business, the government would want to see a larger investment compared to the consulting firm. There are ways to bolster this. So to include a CPA letter, a letter from a certified public accountant that says, this individual is starting a consulting firm. The amount invested is X dollars, and that's sufficient to start a consulting firm. That piece of evidence, it can be a key piece, as well as articles in trade publications. An example I like to use, I had a client who was starting a tattoo parlor, and tattoo parlors don't actually require a lot of money to get started. So what we did was we found articles in trade publications, tattoo publications, where they explicitly talked about how much does it cost to get a tattoo parlor started. And we included that in the application to show the government that the amount invested was sufficient for that kind of business. When you are purchasing a business, and let me quickly add on that, we have in our minds, when we're working with clients, a sense of what becomes a risky amount. So anything below $100,000 in investment, we do begin to consider risky. And what I mean by that is we would certainly let the client know that depending on what consulate they're applying at, the consulate may want to see more invested than $100,000. But as well, in the way we prepare the application, if you're investing less than $100,000 into the business, we start to look at other pieces of the application as especially important. Obviously, they need to be satisfied, such as the requirement that you employ US workers. That's a requirement that applies to every E-2 visa business. But if you're investing a low amount, it's especially important to show that this is a business that has already started employing people, ideally, or that really clearly shows they're going to employ people. So you want to look at those other pieces of the application and how they fit together and really bolster them. So moving on to buying a business, really buying a business usually it's easier to show that that a fair amount has been paid for the business, or a substantial amount, especially if the business is purchased on the open market. So if you've bought a business, you can show, this is a business that everyone had the opportunity to buy. I bought the market value for it. That's usually persuasive. Franchises have their own values for the business. So, typically questions would not come up if you've paid the amount that's necessary to start the franchise per the franchise agreements. For franchises, usually you're beyond the $100,000 mark, though, for many franchises. Do I have to hire employees? The answer is yes. This gets to the marginality requirement I spoke about before. The business must have the present or future capacity to generate enough income to provide more than a minimum living for the applicant and their family. Again, usually this means that within 5 years, they would have employed, I like to say 3 to 5 full-time US employees. 3 to 4 is usually fine. For a startup, we'll actually get into how to prove that in a moment. There is a spectrum here. So the slide says 3 to 4 full-time employees. Those would be W-2 full-time employees. There's a spectrum, though. If you cannot employ 3 to 5 full-time employees, the government will accept, part-time employees, ideally more than 3 to 5 part-time employees. But if it works better for your business to employ part-time employees, that's fine. If 1099 contractors fits better with your business model, the government will also consider that. But keep in mind that it really is kind of a sliding scale. Full-time W-2 employees are most persuasive to show the government you satisfy the marginality requirement. Part-time W-2 employees are a little less persuasive. and 1099 contractors are less persuasive. But if your business is employing, say, 20 independent contractors, you would certainly want to highlight that in the application. And how do you prove that? So if you are purchasing an existing business, fortunately, ideally you would be able to provide tax records that show that the business has employed people. You'd include the past W-2 forms. You could include past 1099s, pay stubs, payroll records. If you have a startup, this is where the business plan is one area where it's especially critical. A business plan is going to show the government 5-year projections for revenue, for income, as well as hiring projections. And there you would show that based on your revenue projections, you are going to be able to employ that 3 to 5 those 3 to 5 workers. So let's talk a little bit more about the business plan. Do I need a business plan? The answer is yes, if you have a startup. If you are working with an existing business, a business plan is less critical, but it would really depend on what other documentation you have. If you have strong tax records showing that this is a business that generates $500,000 in revenue, $1 million in revenue, and has employed 10, 15 workers over the last 3 years, a business plan isn't going to be so critical to that application. You probably could rely on the business's tax documents to show that it's a business that's going to generate revenue and employ workers. But if you have a startup, the business plan is really the key and possibly the only part of the application that shows the government that you have a business that's going to employ US workers. The business plan would typically contain, on the screen, you'll see a few of the key sections that we really we do make sure to include in our business plan. It's an executive summary that really hits who you are as an applicant, what the business is going to sell, who it's going to sell to. Keep in mind that, again, consular officers and officers at USCIS, they're humans. They don't usually spend a ton of time with applications, especially at consulates. So we always think about, okay, if an officer is going to spend 10 minutes on an application, what are they going to read? This executive summary is oftentimes what they're going to go to first. So it's important to have a really strong executive summary that hits all of the points that an officer is going to want to see. We also include market analysis and research to show that the business will be operating in a market that is growing and that has promise. A marketing plan, how is the business going to generate interest in its products and services? A personnel plan, which I mentioned before, 5 years of hiring projections. You'd want to include job descriptions, information about the salary that will be paid, and exactly when you'll hire each employee. So looking out over 5 years, in year 1, how many people will you hire? Year 2, year 3, year 4, year 5. Keep in mind that the government in general won't do an audit on this. So if you get the visa, the government's not going to stop by in year 1 or year 2 and say, okay, you said on your business plan you'd hire 2 workers in year 1. Have you hired those 2 workers? That is not likely to happen. However, when you apply for a renewal, the government will want to see that at that point, you actually have hired workers. It's okay in general if you say, I'll hire 2 employees in year 1, 2 in year 2, and by year 5 I'll have 5. It's okay if there's a delay there, and in year 3 you actually end up starting to hire. In general, that's probably not going to be a problem, because again, the government is going to want to see by the time you apply for a renewal that you have hired US workers. So sticking year by year to the projections will not generally make or break an application, but you do want to try to hire workers, US workers, as early as you can to make for a stronger renewal, and certainly a stronger initial application. And finally, comprehensive financial plan. So you do need to show 5 years of financial projections in the business plan. That's really going to be the basis for showing that you can hire the workers that you say you will. Should you hire a professional? You don't have to. If you're able to develop a comprehensive, business plan that's really backed by solid financials, you can do that. I will say that an immigration firm such as ours that does prepare the business plan, we prepare business plans with the visa in mind. So each section of the business plan, the intended audience is a consular officer or USCIS, and that is key here. This is not necessarily a business plan that you're going to be using to drum up investment from a venture capital firm, say. The intention is really to get a visa, and that is our focus when we prepare one, and that's important to keep in mind. So at this point, I'll go ahead and pass it over to Kelly to talk about a few E-2 visa developments and adjudication trends.
Thank you, Dustin. Great. So we'll kick it off by talking about, the first bullet point here, Buy American, Hire American. This was an executive order that was implemented, previously during the Trump administration. Its stated purpose was to create higher wages and employment rates for U.S. workers and protect their economic interests. This executive order has now been revoked, but what the impact of it that we've seen and the impact we previously saw was really just it made examiners at the consulates kind of more rigorously question the need for an E-2 employee where a U.S. worker could perform the task. So this executive order has now been revoked, but I think we're still, sometimes seeing that at consulates. So to turn to the impact of the Biden-Harris administration, I think that, we don't really anticipate any major changes to e-visa adjudications. We haven't seen any, in the past year. And we really didn't see any under the Trump administration either. So I think the E-2 visas, the vast majority of them are approved. And we've continued to see that under both administrations. So turning to, I think, what's kind of very timely topic, changes in consular processing due to COVID-19. Consular processing timelines, unfortunately, because of COVID, have lengthened significantly. During the height of the pandemic in 2020, consulates completely shut down. Since then, they've been in various states of reopening, and each consulate has been given the opportunity to basically reopen on their own timeline. And of course, country conditions in the various countries and restrictions within those countries regarding who's allowed to go into offices are all very relevant to the various consulates. So, when you're looking at where you're going to file, you really want to look at what are the country conditions in the country that you are planning to file in, as that's going to impact, kind of the consulate's availability. It's really been an up and down. We have seen a trend towards, consulates all really started ramping things back up, maybe operating anywhere from, 40% to 90% of pre-pandemic levels earlier this year. Now, given the rise of new variants, I think, we're starting to see cancellations again. So it really is kind of an up and down. But the key takeaway is that there's going to be, there are significant delays where previously you could apply at the consulate in Toronto and they would respond in 2 weeks, and then maybe you'd get an interview within a couple of weeks after that. Now you're really looking more at a process of, maybe 1 to 4 months. And if you are, a third country national going to Canada, you're also going to need to address, any entry requirements. So, just because you have an appointment at the consulate, that doesn't exempt you from any of the particular country's entry requirements. So for third country nationals and where you can get appointments, it used to be much more open. Third country nationals could get appointments in Canada, they could get appointments in the Dominican Republic, they could get appointments, many different countries. Once kind of COVID hit, once the consulates started reopening, many of the consulates are really prioritizing only their own nationals, particularly in places like the Dominican Republic, Jamaica, things like that, where previously they might have been more open. Now they have limited capacity, and so they're only willing to process residents. However, there are some places that have indicated a willingness to process third country nationals, specifically Frankfurt, London, Milan have all said they are willing to do so, but you need to be able to meet the entry requirements, and any kind of COVID, vaccination requirements, testing requirements. So you want to be aware of that. Another thing to consider, just because of these changes in consular processing, because of these lengthy delays, something that's been happening is if you're already in the United States in a particular status rather than ESTA, you can consider either changing status or extending your status from within the United States. So if you are currently in the US, it's very important to check your I-94. If it's still valid, you have the option to extend or change status while in the United States. If you are already here on an E-2, you will need to, and you applied at a consulate, got approved, now you're here on an E-2 and you want to extend your status, USCIS will ask to see the entire E-2 application, and as well as documents proving that you're eligible for a renewal. So they will kind of assess it as almost a new application because they have not looked at it before. So that's just something to keep in mind if you are going to go that route of renewing from within the United States. All right, so let's talk about some issues and complex areas for E-2 visas. So, one area I think that comes up a lot, and this is particularly for USCIS filings. Consulates don't focus on this nearly as much as USCIS does. So the source and trail of funds involves proving that the investment funds are from legitimate, meaning not criminal activities. Loans are fine as long as they aren't secured by the assets of the business. Ideally, they would be secured by your personal assets. A personal line of credit from a bank is also fine. Additionally, unsecured loans are okay, but if the repayment terms are aggressive, the officer may be concerned that the business is too highly leveraged. So if you are going to go the route of a loan, it's very possible to use that for your source of funds, but you want to, just speak with the attorney and make sure that, that it's not secured by the assets of the business. Gifts are also fine, but the gift giver has to be willing to provide evidence to document the source of funds. So a gift letter on its own is generally is not going to be enough. The gift giver, for example, if they got, if the gift is from, savings from their own employment, then they would need to provide their tax returns. So the gift letter alone is not enough. Another area that comes up a lot in our practice is a small investment amount. So, some investments are just going to be too small. So for example, if you say I have $5,000 to invest, that's just never going to be sufficient. What they consider a small investment, many consulates, is under $100,000. So if you are going to go ahead with a small investment of under $100,000, it's important to really explain why this investment should be considered substantial. So for example, providing market or industry reports from respected publications with estimates for how much the startup costs are for your type of business, that can be very helpful. If you have a small investment amount, it's also important to make sure that all the other parts of the application are extremely strong. So, real and operating, you want to have a lot of documents for that. You want to have a detailed business plan with financials that make sense. You want to have contracts with or letters of intent with future clients. You want to have letters from local business organizations or chambers of commerce, that are supportive of the business. You may want to hire employees as well. That's also something that can make the marginality aspect of the application very strong. So if you have that small investment amount, you really want to bolster all the other parts of the application. So moving to E-2 visas for 2 investors. If you're going to do this, this arrangement, the ownership must be 50-50. And ideally, you'd be investing either an equal or a mostly equal amount. You also want to make sure that each of you has a specific role within the company, or an explanation of why you're both necessary. So, if one person could be a CEO, one person could be a CFO. It doesn't need to break down exactly like that, but there should be kind of an explanation for why both people are needed to develop and direct the business in the US. And it's also good to note, some consulates will actually allow you to be interviewed together. That's kind of consulate specific. So if you're doing an application with 2 investors coming over at the same time, you want to kind of get in touch with a consulate to see how they'd like to receive the applications. Something else that comes up a lot are substantive changes to your business after your filing. So if there's any changes in the ownership structure, You want to just remember that the business has to always be owned at least 50% by treaty country nationals. If you fall below that ownership, the business is no longer an E-2 business. And even if you have a visa, like a 5-year visa, if the ownership goes below that 50%, your visa is technically no longer valid because the business doesn't meet the E-2 requirements. Additionally, you want to think about any changes in your type of business. If your business is changing drastically, for example, you're a consulting company and you decide you want to open up a restaurant, you need approval from either a consulate or from USCIS before you can start operating the new business. So you should not kind of sell your business and start a new business and then seek approval. If you're in the US, you want to get that approval first, and then you can operate the new business. That being said, if the change is not substantive, like let's say you're running you're a wedding photographer and you start a wedding and photography blog, that's not, it's kind of a new service line, but it's not something that is so drastically different that you would need approval before starting that. Additionally, if you contemplate multiple lines of business in your initial application and your business plan, then you may not need to go back and get approval later because it's something you've already presented to the consulate or USCIS and had approved. So for example, we've had a client who opened up, a gas station and a wood shop at the same time. So those kind of disparate or multiple lines of business can be contemplated. Or it's very common that we have clients who are offering maybe software consulting services, but plan to develop an app in the future. So that's fine as long as it's contemplated in the business plan and the consulate is aware of it at the initial application. Finally, family business purchases, this is something where if you are purchasing a business from a family member to, either outright or to run the business with the family member, you can expect that the consulate may be, just a bit more suspicious. They want kind of additional confirmation that this is, really a viable transaction and you're not just moving money around between family members. It's good to perhaps get a third-party valuation to prove that there's an objective, that the amount that you paid is really the fair market value of the business. You want to kind of, if the source of funds obviously should be completely separate from the family member you're purchasing it from. So you want to just keep in mind that you want to put those things in place when you're purchasing from a family member. All right, so let's turn to common reasons for E-2 denials. So one is a low investment amount. If the investor has more money, this can be a relatively easy fix. You invest more money and you reapply. Another thing you can do is you can gather industry evidence to support that the investment amount is substantial in relation to the total cost to set up the business. So that's kind of those market reports, industry publications. Additionally, you could have a CPA review the business plan and the investment schedule and write a letter confirming that the investment is substantial for the startup needs for this type of business. So another reason for denial is perhaps the nature of the business. Some businesses are just inherently riskier than others. For example, consulting businesses, there's often a concern that the person is going to come in and be a solo consultant in the US, and that's really not what the E-2 is for. It's really to create and develop and direct a business and hire US workers. So if there's no proof of contracts for consulting business, that's going to be very risky. Additionally, real estate businesses are also very risky, as are, kind of equity or trading businesses. So those are the types of businesses where you want to really have other strong aspects of the application to make sure the officers are comfortable. Another reason could be, filing location or venue. Some consulates are just more E-2 friendly. Toronto and London are two that are have very robust E-2 operations and officers that are very aware of the regulations. USCIS is less concerned with some issues. For example, you could have a lower investment amount and USCIS will generally, that's not as big of an issue, but they do require a dollar for dollar accounting of the source and trail of funds. So if you have a source and trail of funds where perhaps you received the money several years ago and tracing it's going to be very difficult, that may not be a good filing for USCIS because they are very, very, kind of concerned about that. So another issue is concern over whether the business will create jobs for US workers. One thing to consider is if you previously ran a similar business in another country and you've never hired any employees for that business, that can be a red flag. That's something where the officers may look at your history and say, well, we don't believe that you're actually going to hire US workers. So in that type of case, you may want to consider actually hiring workers in the US before you get the visa to help address that concern. Another reason could be just issues with the adjudicating officer. So the, consular officers have complete discretion over whether to grant or deny your visa, and there is no appeal process. However, if you do reapply, most consulates will try to give you a different officer. There's not a guarantee that that will happen, but it's a general practice at most consulates. And then another reason is perhaps you just didn't meet the requirements at the time of the filing. So, for example, we had a client that came to us, where they had put $98,000 in a business bank account and spent $2,000. So, as I said before, some investments are just too low. So a $2,000, investment where $2,000 is at risk is just too low. We advised them on how to, spend additional funds, and then they reapplied and they were approved. All right, so what does it take to renew an E-2 visa? Hiring US workers, that's really a very, very important aspect. Many consulates, particularly ones that do a lot of E-2s, will only ask to see the tax returns and the W-2s or 1099s when you renew. So that, really goes to show that the most important thing that they want to see is that jobs are being created, particularly for US workers. If your industry is largely based on paying independent contractors, for example, sometimes in construction, that's very common, you can argue that this counts to prove that the company supports more than just you and your family, but it is a weaker argument. And if you're going to do that, you want the amount paid to independent contractors to be quite high. So for example, if let's say you paid, $200,000 to independent contractors, in a construction scenario, that might be okay. We'd still recommend, you still need to have, US workers, at least a couple employees that are actually employees of your company. So updated financial data, that's the other important thing they really care about. It's good to think about, did your company meet its revenue targets? It's okay if you submitted a business plan. If the company didn't meet the business plan targets, that's okay, as long as the company is earning enough money to support employees. Consulates really rarely point back to the original business plan as long as the company is doing well. So if you said you were going to earn $700,000 and you only earned $400,000, that's okay, as long as the business is still, turning a profit and has employees. So another thing is the company profitable? Revenue, I'd say, is more important than net profit, but showing profit is definitely good for the application. It's not a problem if the company is running a small loss, as long as the financials show good cash flow and an ability to keep paying employees. Another thing to consider is, whether your marketing and sales plan worked effectively to increase your business volume. The cover letter should highlight any company achievements. It's always good to be able to highlight, large successes. For example, did you sign any particularly prestigious clients? Did you garner, positive online reviews? Have you expanded your services? Have you purchased new equipment? Have you expanded to a second location? All those things, should be highlighted in an application. You can also provide updated proof the company is real and operating. So if you've, enhanced your website, if you've gotten new business cards, if you made new brochures, all of those things can be included. And then proving that the company still meets the E-2 requirement. So you don't need to make any new investment, but you do need to show that the ownership still meets the E-2 criteria. So at least 50% owned, by treaty country nationals. And if you are the investor, at least 50% owned by you. Usually they'll want to see tax returns that support this ownership. And then any changes to your type of business. So, the company should still be providing the services it represented during its initial application. It's okay if it changed due to market forces. Let's say you have a marketing company that's targeting the healthcare industry, but then, you really ended up getting a lot of finance clients because that was more successful, but you're still providing marketing services. That's okay. If your business line changed entirely, as we discussed before, let's say consulting to a restaurant, that's going to be more of an issue for renewal.
Great, thank you, Kelly. So we are now on to the questions and answers. We have about 10 minutes. A few of the questions I think are pretty specific to certain applicants, certain attendees situations. So for those, I'd encourage you to consider setting up a consultation so we can really go into detail and into your situation and give you good guidance on that. One question did come in that I thought was a great question and touched on something that I mentioned before. When you say you should not be providing services, what if your business is a service business that you are the professional qualified for? So before, if you recall, what I said is that the requirement for an E-2 business is that you develop and direct the business. If you're applying at USCIS, you should keep in mind that you are supposed to be really taking a macro role on the business, really, like the regulations say, developing and directing the business versus providing direct services to clients. This is less of an issue at a consulate, but for USCIS, a great example. I had a client who is an accountant, and she wanted to start an accounting firm in the US, and she was applying through USCIS. That was a very risky application because she, being the sole accountant, was obviously going to be the person providing accounting services. So it would have been an extremely risky application if she were telling USCIS, I'm applying to start an accounting firm, I will be the only accountant providing services. The way to mitigate that risk is for her to hire other people to provide accounting services. By doing that, she can then show that her hired accountants are going to be providing accounting services. She will be developing the business, networking, advertising, supervising, hiring and firing employees, but she's not going to be the main person providing accounting services. Again, this is less of an issue at consulates. It is an issue with USCIS. But again, one way to really address it is to hire workers early on to show that there are other people providing direct services. One of the ways to think about this is the E-2 visa is the E-2 investor visa is intended to bring into the US people who are not actively competing in the labor market. Entrepreneurs are not really competing with other entrepreneurs in the labor market. However, an accountant is competing with other accountants in the labor market. So keep that in mind, especially if you're applying at USCIS. So Kelly, there were a few questions. If you don't mind, I'll go through them and let you respond to a few if that sounds good to you. This first one says, what if I have a pending immigrant visa application when I'm applying for an E-2 visa?
So it depends, I think, what you mean by a pending immigrant visa application. If what you mean is a relative has filed an I-130 petition for you, and there's kind of a long dated priority date on that, there's a long wait for you to actually get your immigrant visa, then yeah, it's generally not a problem. It does need to be disclosed on your DS-160 when you apply for the E-2. But often you can say, it's very long dated, not going to have an ability to kind of apply for the green card for many years. So it's not something they'll really focus on. If you're farther into the process and you actually have the green card petition pending at the consulate, then that's something where getting an E-2 is going to be much more difficult or, perhaps not possible at a consulate. So it just depends kind of where you are in the process.
Great. And then a related question, Kelly, is, and I should preface this by saying we have some YouTube videos on it, and actually an entire webinar on exactly this question, but the process of moving from an E-2 to a green card, is that possible? What does that look like?
Sure. So yes, it is possible. There is no kind of direct path like from an E-2 to a green card. But if you're in the United States on an E-2 visa, let's say, and you get married to a U.S. citizen, you can certainly file a green card application. Similarly, as Justin said, we go through this in our webinar, but there's other options. For example, EB-5, if you end up investing kind of a much more significant amount of money. Additionally, the national interest waiver is something that may be available. So I would encourage you to kind of check out that additional webinar, but it is possible to get a green card, while you're on an E-2.
Great. And then Kelly, I'll send one more question your way, and then I'll share and answer a few. If a principal applicant applies for an E-2 through USCIS, what is the process for family members back home to apply for E-2 visas?
Yeah, so I mean, I'd say technically there is a provision in the Foreign Affairs Manual that allows those family members to go to a consulate and try to get visas so they can come to the United States. That being said, I think consulates can be quite difficult about it, and sometimes will ask for the entire E-2 petition to be sent to them so they can essentially adjudicate that anew. So it's not the most straightforward process, I would say, and it may be that the consulate, depending on which consulate you're dealing with, declines to issue the family actual visas until the applicant themselves comes to the consulate to get a visa. So it really will depend on the consulate you're dealing with.
Perfect. All right, so there's a question here. How long is the process? And once I get the visa, I can come and live in the US, correct? So the process, if you're applying at a consulate, the process really does vary. Let me start off by saying that we at our firm prepare E-2 applications. Once we get all of the necessary documents from our client, we can turn around an application in 15 business days is what we guarantee. We do offer the option of a 5-day turnaround for an additional fee, but that's fairly insignificant in the process of applying because consulates really do range in terms of how long they take. So to blend this question with another about the process at a consulate, you would first submit a form DS-160 online at the consulate. That's fairly quick. And immediately after that, you would, or we would, if we're preparing the application, submit the supporting documents to the consulate. And that's really all the documents that show, the business plan, your background as an applicant, that you've invested funds, where the funds came from, all of that would go to the consulate. And basically at that point, we wait for the consulate to perform a preliminary review of the application and to say, okay, now you can set up an appointment to come in for an interview. On this, consulates, like I said, really do vary. Right now, there are some consulates moving very quickly, where from the point of submitting the application, it can take as few as 2 or 3 weeks to get an invitation to schedule an interview, and you could have an interview within a month of submitting the application. There are other consulates, such as Rome, that appear to be taking between 9 months and a year from submitting the application to actually scheduling the interview for an E-2 visa. Toronto, London, those consulates, which we deal with quite frequently, are in the middle. Right now, Toronto's looking at about 2 to 3 months. London, a little bit longer than that, last time I checked. Once you have your interview, usually you'll get your visa, if you're approved, within a week or two of having the interview. So hope that sheds light on the timeline. Again, it really does vary on which consulate. If you're applying through USCIS, you have the option of applying for premium processing, which guarantees you a decision, whether approved, denied, or a request for additional evidence within 14 calendar days, which is great. They charge an additional fee for that, however. There is another question. Can I take over the business and start working on it before applying for an E-2 visa? The answer would depend on what your status is in the US. If you have a B1 visa, for example, or are on ESTA, and you have come to the US essentially to perform business activities, you can perform a range of tasks short of actually working for the business. You cannot work without work authorization, even on a B1 visa, but you can do things like setting up a lease, hiring workers, going to meeting with other people in the field, trying to, sign contracts with prospective clients, for example. be careful of that because, again, you can't cross into actually generating an income unless you have work authorization, which you would have once you get an E-2 visa. But you can set up the business. And again, going to this idea of employing an employee, you can hire someone to act as an office manager, and that person can then be paid for their work and can do the things that you yourself would not be allowed to do without work authorization. Kelly, I'm quickly running through these. Did you see any other questions that you wanted to answer? I know we're short on time here.
No, I think we covered everything.
Perfect. Well, thank you all very much for taking the time to join us. Kelly, thank you very much for sharing your expertise. I just want to quickly end by saying we'll follow up with the attendees on this with an E-2 guide, as well as an invitation to our future webinars. Do check out our YouTube channel. If you search Scott Legal PC on YouTube, we have a range of webinars on a variety of immigration topics there. And we also post a lot of free information on our blog. We have at this point, I think, several thousand blog posts on a variety of immigration topics. So we really do try to make information free to the extent possible. So thank you all for joining us. We hope to see you again on future webinars. And in the meantime, stay healthy and well. Thank you so much.